Good morning, everyone. It's 10 o'clock and this inquiry is now open. Can everyone hear me, first of all? Thank you. If at any time you can't hear me or anybody else is speaking, just raise your hand and let us know, and we'll try and speak louder or speak more into our microphone. So thank you very much, everyone. So throughout the course of this event, as I say, if you can't hear us, please do let us know. Can I ask that everyone switches off their mobile phones or sets them to silent? And also, could you all make sure that other alerts on your other devices are put onto silent also? Now, my name is Mrs. Dillon and I'm a Chartered Town Planner, and I've been appointed by the Secretary of State to hold this inquiry. Now, Ms. Charles and Ms. Dutton are the case officers who've based remotely at Bristol, and they've been assisting me with the running of the inquiry, and they'll continue to do that throughout the course of this week and next. So if you do have any queries which need to be raised outside of this room, they would be your port of call. Now, this inquiry is an appeal made by Gleeson Land under Section 78 of the Town and Country Planning Act 1990, and that's against the failure of Basildon Borough Council to issue a planning decision for an outline planning application, and that application was described as outline planning application with all matters reserved except means of access for the erection of up to 200 homes, a new vehicular access comprising a new arm off Landon Road, the A176 and Norkill Road roundabout. The realignment of Kennel Lane to join the new access and associated closure of the existing Kennel Lane spur. And that's together with car parking, landscaping, surface water drainage basins and associated works. Now, I've just had to be very specific with that description, just for anybody who's not used to the appeals process. And that's at Lange to the north of Kennel Lane, Billericay in Essex. Now, I apologise if I mispronounce any names of anybody or any places throughout the course, and please just correct me if I do so. So just first of all, just want to make sure that that's everybody who's here's understanding of why we are here today. Okay, thanks, that's a good start. Now, firstly, there's some important formalities that I must attend to. And so that we can get through these swiftly, I'd appreciate your full attention. Rest assured that I'll give you all the opportunity to ask any relevant questions at suitable points as I go along. So just please bear with me for the time being. In terms of emergency procedures, I'm not aware that we're expecting any fire drills today. There may well be one later on Friday when we're sitting virtually, and we'll deal with that at the time. But if the alarm does sound today, that means it's real. So we all need to keep calm and leave by the nearest exit, which you've got doors on either side, into the corridor. I believe down the stairs, there are signs for the fire exits, and out to the front beside Wilco's is where I've been asked, and then we would decide what we did from there. But the main thing is that we all leave in an orderly fashion to get there. Now, in terms of toilets, they are, if you come straight out those doors and to your right, and then a sharp left, through the double doors, you'll see some signposts to the toilets. Just make sure that you come out the way that you went in, otherwise you might end up in a lobby where you need a badge to get out, but don't panic. And also, some of the doors I've noticed you need to press, there's a button that you need to press if they don't open straight away from you. So again, don't panic. There will be a button or something to get you out. So other than water, because I believe there's a water dispenser over in the corner there, we're not permitting any food or drink in the room, please. But obviously, water is fine. And You can leave at any point, either if you need a comfort break, or if you've heard what you need to hear, you can leave at any time. Just do so quietly, and likewise, when you come back in again, just try and take your seat quietly, so we don't disturb the proceedings. Now, just moving on to the event format. Obviously, we're here in person today, and the event is being live streamed. I see that I've gotten, there's a side profile of both me and some of the participants around the table. I think that's probably the best way to get everybody in on the camera angle. So apologies for my side profile, but that's just something that we can live with. Now, the main parties have previously agreed that the inquiry could revert to a purely virtual format after today, and that will be via a Zoom link, which you all should have. If you don't have that and you're wishing to observe or participate in the remainder of the inquiry after today, please contact the council and they will provide you with the link. Now, there are some practicalities and protocols regarding virtual events, which is a little bit different to a live face-to-face event, but I'm not going to go into those today. We'll deal with those on the first virtual session. I'll run through them then. So I think I'll ask you all that throughout the entire course of this inquiry, please bear in mind that there may be some people here who are unfamiliar with the appeals process, may be quite upset about the proposals, and I will seek to help in that regard, because I do appreciate if you're not dealing with this type of thing on a daily basis, it can be quite daunting. And I want to make sure that it's as I'll not say it's enjoyable, but it's something that you can go away and think, yes, that was it was well run. I was able to have my say if you want to have your say, and it's been conducted in an efficient and effective manner. So I just appreciate everybody's patience and understanding in that regard. I'll need to make sure that everybody can hear me, and also that I can hear them, and that's today and throughout the rest of the inquiry. So unless you're actually involved in the proceedings, a witness advocate, then just please refrain from having any side discussions or clapping or jeering. I'm sure we're not going to have that today, but I'd just like to set the marker down as to the tone of what we're doing. If you do want to draw my attention to anything or ask a question, raise your hand and just wait to be invited to speak. I'll try to look around the room, but obviously it may be that you have to do a wave rather than just a straight hands up to get my attention. But I'm sure somebody will keep me right if anybody is wishing to speak. Now, when you do speak, just make sure that your microphone is switched on, and it should show a red light as mine has on. I'm hoping that I don't need to exercise my powers to remove anybody from the proceedings. I'm sure I won't have to do that, but again, it's just another marker I like to put down that is a possibility for me. Not that I've exercised that yet. Now, I'm conscious that you will see me taking notes as well as looking at documents on my laptops. And also I might get up from time to time if I need to have a look at something which is a hard copy. Don't let that put you off. And it doesn't mean that I'm not listening to what's being said. I'll be asking any pertinent questions to aid my understanding and to get what I need to get out of this event to be able to determine the appeal. However, if the advocates and the witnesses are doing their jobs well, then they've probably already anticipated the questions that I'm likely to ask. And just don't take any questioning or lack of it is an indication of the robustness of the evidence or the likely outcome of the appeal. And that's for the purposes of interested parties who are listening, and also the witnesses. You might find that I've got more questions for one witness than another, and that's just not to, it isn't a signal of anything. It's just I need to go away with a full and complete understanding. Now, where the need arises for communication to occur between the attendees during inquiry sessions, then just do that without interruption, please. We do have internet connection, so I imagine you have chat. You know, I don't mind if there's a chat going on, as long as it's not disturbing and it's actually necessary and related to the inquiry. And the normal limitations between the witness and the team during the course of the evidence and given in cross-examination will apply. We'll not be, I doubt we're going to be hearing any evidence today, and it's going to be more a case for the virtual events where there will be an element of trust, because I'm obviously not going to be about, and I'll expect that both parties will abide by that. Now, just in terms of Wi-Fi and internet, I'm advised that you're able to all connect to the council's website, or should be able to, and there's no password required. I've got, my connectivity is a little bit hit and miss at the moment with my my corporate part of the website for me, but I've got hard copies and I've got backup systems in place, so I should be okay today. Is there anyone here who's got difficulty with connecting to the internet we need to address, or is everybody quite happy? Thank you. So with the wonders of technology, we'll be able to share documents electronically through the inquiry, and that'll be particularly useful when we revert to the virtual format. Now, this will be permissible through the proceedings only where I agree to it, and it will be subject to the same considerations as late evidence, if indeed it constitutes late evidence. It may be something that I've asked for, in which case that's okay. And any late evidence, I would remind you, can have cost implications. Now, anything to be shared, it would need to go back to via our case officer at Bristol, and then she would then circulate it. Now, it's crucial that in the interest of openness and fairness, that before, during and after any session, I'm not left alone with any party. So when we adjourn, just please remember, if we let me leave the room first before you do, and then we know, everybody knows that I've left and I haven't been left with an individual person. And that's so that I can't hear or see anything or be influenced by anything that I shouldn't be, because this is an impartial, fair process, and that's a standard that I uphold 110%. As awkward as it can be, if we do come across each other in the corridor or in the, you know, we're having a comfort break, don't speak to me, because I'll not be able to speak to you, and it's quite hard. It's quite a difficult thing to do. But you may get a smile or an acknowledgement, but I certainly can't engage in conversation. And I'd just like to ask somebody from the council: are the attendees able to stop in this room during the break?
We haven't got a set breakout room here for them, but we do have the Town Break Theatre, which is right next door by the main doors where you can go and get tea.
Right, but they can stay here if they wish to. Yeah. So you've got the option there, and I would imagine a lot of you will be local, so you'll know your way around better than I. If you do stop in the room, and this is just something, again, if you anybody watching virtually on via Zoom system, is that you will be remaining audible and visible to other participants. So just exercise any caution if you're having any discussions in the break. And you'll be expected to rejoin the session in the same manner as you did at the time that I would state when I adjourn. So does anyone have any questions or concerns about the just housekeeping practicalities before I move on to sort of more finer details? Okay, thank you. So I'll start with the appearances now for the appellant, counsel and interested parties. I'll just take introductions back from each of the advocates, and if you can give me the names of who will be speaking through today and through the course of the inquiry. And I'm happy for you both to either stand or sit, whichever you feel comfortable with, just where you are. I realise we have got a table there for any sort of witnesses and interested parties, but I'm quite happy for you to whatever you feel comfortable with. So I'll just start with the appellant, please.
Good morning, madam. My name is John Litton, Litton, King's Counsel, and I'm representing the appellants, Fleece and Land Limited. And madam, I anticipate calling 3 live witnesses at the moment, and they will be, I think in this order, Elizabeth Symes from Fabric on landscape matters, Jacqueline Mulliner from Terence O'Rourke on planning matters and 5-year housing land supply, if we need to have a discussion about that. And then Ben Howard from iTransport, who addresses highways and transportation matters. I'm conscious that I haven't provided you with their qualifications, and we're going to provide you in writing in the course of today, full names, full details, full qualifications, if that's all right.
Helpful, thank you. And for the council.
Good morning, madam. I represent the council, Giles Atkinson of Council, and I will be calling 2 witnesses, Gordon Humphreys on both planning and landscape matters, and he, by way of qualification, is a BA and MA and MRTPI. And live, well, at the round table, Robert Davey, dealing with housing land supply, and he is qualified to BA and MA level.
Okay, thank you. So it's my understanding that no one has sought Rule 6 status. Is that everyone else's understanding? So I have representations to both the planning application and to this appeal from a number of interested parties, or local residents, but I'll refer to you as interested parties through the proceedings most of the time, I would imagine. Now, I have read these, and I think that's really important. I do want people to appreciate that I have read these, and I will read them several more times during the inquiry and after, as I'm deliberating with my decision and writing the report. Now, they will help inform my decision, and there's no need for any matters that have been raised to be repeated. So I just want to give everybody that assurance that, you know, it's a serious matter, and they are taken. So they're taken as read today, is what I would say. I do have a list of interested parties, a short list, people who have indicated that they wish to speak, and that's fine. I need to establish whether or not they're here now, so that we can just agree at what point they would like to speak. Now, before I name those parties, if you are going to speak, I'll be asking for your name and address, who you're representing, whether you're representing the group or just yourself, whether you have any specific time restrictions, and whether you're opposing or you're in favour of the appeal proposal, and whether you'd be prepared to answer any questions from the appellant, as that would increase the weight that could be attached to your representation. So just so everybody knows, that's what I'm going to be asking before I actually read the names, because I can appreciate public speaking can be very daunting. So in no particular, or it's no particular order, I've got Councillor Dr. Richard Moore, Bursted Ward Councillor, Basildon Borough Council. Is Councillor Moore here? Hello there. So I've got your name. So are you who are you representing?
I'm representing my ward.
Thank you. And you may have seen from the programme, we've got I've factored some time in today after we finished the opening statements to hear from you, if you've got time, if that's convenient for you today, rather than pushing it back. And I think it's probably quite a good, one of the reasons I was quite keen to definitely have a face-to-face on the opening, is just so that everybody who might be watching or involved throughout, we've all sort of met each other face to face. I always think it's a better thing to do when you're reverting to virtual. So do you have any specific time restrictions? Are you okay for before lunchtime?
I'm okay before that.
Okay. And can I just confirm, are the people that you're speaking on behalf, is it opposition or in favour? Don't want to be presumptuous at all. And would you be prepared to, in terms of any questioning, would you be prepared to be questioned? Okay. Thank you. Now, I also had a Mr. Grills on behalf of Mr. and Mrs. Meads. However, yesterday I was advised that, as they understand that the representation's taken as read, and obviously I've explained that now, they didn't feel it was necessary to repeat anything that was within that. I'm just wondering, is Mr. or Mrs. Meads here today?
I can speak for them because Mr. and Mrs. Meads, that's my sister and my brother-in-law.
Okay.
And Alistair Grills is their planning consultant.
Yes.
And he's written quite comprehensive.
Yes, he has.
So we didn't want to.
Yeah. No, that's appreciated. Yeah, that's appreciated. Yeah, just wanted to check that. Now, there is a request in their letter, as there is for a neighbour as well, regarding the site visit. We'll come to that later on. I haven't forgotten about it. It's just I'd rather deal with it all together when we're talking about the site visit, so that it doesn't get missed. So thank you very much. And then I have a Helen Watkins. Oh, right, okay. So again, similar to, I'm not quite sure, I didn't get a message to say you weren't going to speak.
I am, but my comments were actually around the site visit. So maybe you want to help me for that.
Yes, so were you wanting to, was there anything that you want to expand on in terms of your representation?
No, I'll take that.
Right, okay, that's fine. So we'll deal with that later. Thank you. Okay, so as I said, Councillor Moore, it'll be looking at it'll be after the Mr. Atkinson's opening statement. So something around 11:30, hopefully, if not before. So is there anybody else here today who would like to speak or will want to ask questions of the opposing witness at the appropriate points in the programme?
I might be interested when it comes to the expert witnesses.
Okay, and you'll see in the programme that I've made time for that after everybody. So just at that point, if you want to, we'll be virtual at that point. So you just need to make sure that I'm aware that you're still there and that you want to speak. Okay, thank you. Hello there.
Process. But I might want to ask questions if that's possible.
Right, okay. I'd just like to, Mr. Atkinson, Mr. Litton, would that pose any concerns for either of yourselves?
No, it doesn't. As I've indicated already, I mean, there are currently 3 witnesses that we would propose to call formally. So they are dealing with planning matters, landscape, and highways and transportation. You're aware that we have put in some technical notes dealing with some other issues, so ecology, for example, flooding. And we weren't proposing to call those witnesses specifically. I'm not sure, obviously, what questions Mrs. Watkins or Mrs. Lewis have, but if they relate to, for example, matters of flooding, it would be useful to know in advance,
Yes.
And then we can try and make the relevant witness available for that. I can't guarantee it.
Yes.
But if there is a particular question that falls outside of the planning, greenbelt landscape issues and or transportation issues, then if they could indicate that to us sooner rather than later, we will endeavour to make those people available. I think you've essentially put in a slot on Monday of next week to be able to do that.
I have. That was yeah. And I think where we weren't. I'm still not sure whether or not you're
going to formally call them.
Yes.
Well, I wasn't going to formally call them because they're not obviously issues as between the main parties. Mm-hmm. But if there are particular questions, then as I say, which relate to, say, flooding or possibly ecology, then I'll make sure as best I can that those people are available. They'll be available virtually, obviously, because we will be virtual in the event.
Yes, yeah. So I wonder whether Mrs. Watkins and Lewis, if you could, did you hear what was said there? It would be helpful. It'll just help with the programming. Even if you haven't got the specific question, if we know what the general scope is, so that we can just make sure that people are here if they need to be, but that we're not wasting people's time if they don't need to be. I think.
Absolutely not. No, I mean, I was just planning to listen to the evidence, for example, on landscape, and if I had a question,
yes,
I would ask, but I wasn't going to bring any questions that weren't already
then
related to the timetable. So.
And Miss Lewis, is there a particular scope that you're?
Well, I'm just concerned about traffic flow around Kennel Lane in front of the school in particular, which is incredibly
right. Okay, so in terms of traffic, and were there any other? Is it principally traffic? Yeah. Okay. So to be quite honest, we can pick that. We've got. I had put time in the programme for your Mr. Howard for evidence in chief on Thursday, so I wonder whether we can deal with it.
Yeah. I mean,
Then-
Mr. Howard will be available for
Yeah.
questioning. I'm going to formally introduce him. It's not going to take a great deal of time.
Yeah.
But there will be the opportunity on Thursday, as you say, for residents to ask him questions,
Yeah.
because we're conscious that traffic is a particular issue for them.
Yes, yeah. So just to check, will you be day 3, which is Thursday the 29th? Will you be available? It would be in the afternoon, and at the moment we've got it for 3:30 for the highway side of it. 3 o'clock for the evidence, and then 3:30 or thereabouts. So just make a note of that. Yeah. But if you just, and this is just a word of caution for everyone, just for you to, the programme may well change. Sorry, I've just been locked out. The programme may well change throughout the course. We may speed up, we may slow down. So if everybody just keeps an eye on the council's website, because we'd seek to update, or at least so you may just, the wonders of virtual are that you can drop in and out as and when you want to. So. Okay, is there anybody else? No, so. And just if anybody changes their mind throughout the course of the inquiry, just let me know and we'll try to accommodate you the best we can. But as you see, we do have a time set aside for opposing interested parties to question the witnesses, so it should cover most eventualities. And just for the purposes of today, Councillor, if you can either come to the front, or you can to speak, or you can speak from where you are. The only thing I'm conscious of is you haven't got a microphone, so you might, if you want to come to the front, you'd be welcome to, on the table at the side there, welcome to do that. Okay, thank you. So just for everybody's benefit as well, if you do speak or give evidence, ask questions, your name will be noted on the bottom of my decision letter. And I just want to check, is anybody here from the press today? And is anybody intending to film or record the event other than what's going on to the side of us? Okay. And is everybody comfortable with the view of the screen? If anybody needs to move, I'll give you a couple of minutes to move now if you don't want to be in shot. I think we've more or less got the main parties, I think, haven't we? We've managed to do that, so. Okay, so just moving on now. Now, we had a case management conference call, and that was between the council, the appellant, and myself, and that took place virtually on the 19th of August. That's a standard thing that we do, and it's held to discuss the procedures of the inquiry and how it's going to run, not the merits of the case at all. And there should have been a note of that posted on the council's website. Now, just for those who weren't there, the types of things that it covered were the event format, the scheduling and the management arrangements prior to and during the event, the scope of the main issues to be examined through the inquiry, the most appropriate means of actually examining each matter, and the arrangements for how interested parties could raise their concerns or any outstanding issues during the proceedings. And also we talked about the scope of the programme and the timetable for the submission of further documents that were required for the appeal subsequent to the planning application. And this included the potential for a planning obligation and a list of planning conditions, which is a standard thing that we have to have in place for any appeal, regardless of what the outcome of that appeal is. Also an agreed core document list. So there's a list of and a set of documents on the council's website which are publicly accessible. They are all the documents relating to the planning application and the inquiry. And also a compliance statement for the planning obligation. And we also discussed the need for statements of common ground. They are documents where they set out the areas or aspects of the case that the parties agree on and also disagree on, and that makes for a more efficient and effective inquiry, because we can then drill down to the key issues. And obviously being mindful, in this case there's a lot of common ground between the council and the appellant. However, there are opposing views from the interested parties, and obviously that part of the appeal is for me to examine those and to listen to anything that's said. Now, in terms of procedure, I'm going to be following the inquiry procedure rules of 2000 for the running of this inquiry. And I'm just presuming that the main parties are fully familiar with these procedures. Yeah. And as I said earlier, interested parties, I'll aim to narrate as much as I can so that we take you along with us, and we don't go down a route of talking in a lot of technical jargon that you can't understand. So hopefully my narration and explanation as we go along will help you. Now, does everyone have a copy of the programme which was circulated? It was finalised on Friday afternoon, so it's been posted on the council's website. Now, does everybody have a copy of that? Yeah. Okay, just in terms of evidence giving format, I'm just going to outline the normal procedures, and that's just for the avoidance of doubt, and because we do have some attendees here who may not be familiar to the inquiry process. So when I've concluded my opening remarks, I'll invite the appellant and then the council to each in turn make a brief opening statement. So that'll be around about 15 minutes where they'll present the main case. And that'll help everybody sort of hopefully understand the main arguments. And then, as I said earlier, we'll hear from interested parties. Now, after that, I think today we'll be adjourning the sitting, but we need to have a conversation about the site visit, which we'll do a little bit later on. Now, as agreed during the case conference call with the main parties, it's been agreed that the main issues will be dealt with through the formal presentation of evidence and cross-examination, and also what we call roundtable discussion. Obviously, the evidence given in the roundtable discussion will be virtual, so we won't really have a roundtable. It's just a little bit, it's still formal, but not as formal as, it's more discussion than the formalities of evidence given in cross-examination. And that's a discussion, we'll have an agenda, and it's a discussion that I'll lead on. And I'll share the main issues with you a little bit later. So once we start the virtual sessions on Wednesday, we'll hear the evidence starting with the council's case first. I think because of the way the alignment between witnesses, I think what I'd said, it's probably easier just to deal with Mr. Humphrey's evidence first.
That's right, Madam. I think you said Wednesday.
Yeah, sorry, Thursday. I beg your pardon. Yes, Thursday. Yes, sorry. We'll deal with that. We'll deal with that first, and then the appellant's advocate will have the opportunity to cross-examine the council's witness, which will be Mr. Humphreys. And then the council's advocate, Mr. Atkinson, may wish to put some questions in re-examination of his witness. Before the re-examination, both myself and any interested parties who are on the opposing side will, supporting the proposal, will have an opportunity to speak, to ask any questions of the witness, so that be in support. The appellant will then present their evidence in the same way. So we've heard from Mr. Litton that we've got three principal witnesses there. And then again, I'll indicate when interested parties who oppose the proposal will be able to ask questions of the appellant's witness. And then again, I may have some questions. Now, it may be, I do try to stick to asking my questions because I don't like to interrupt the flow, but there may be some times where I need to ask a question because I can't move on in my own thoughts without the answer. And I would do that in a way that hopefully won't interrupt your flow. Now, given that this is an appeal against non-determination of a planning application, i.e. a decision notice wasn't actually issued, then we have built in into the programme sessions to allow us to discuss some matters that aren't necessarily in dispute between the council and the appellant, but obviously that there has been opposition from the interested parties, and also in respect to house and land supply. There's a lot of commonality, I think, between the parties. We've reached and I appreciate being reached a point, and we know where the areas of dispute remain, and there's an agenda that should have been published for that roundtable discussion. So really the what I'll call it's a reserved sort of general session, that where we would be picking up if there's anything in relation that I want to ask or is a matter for the interested parties around archaeology, flood risk, ecology, and then if there's anything, I suppose, that is flushed out from from any of the other sessions that needs to be picked up. And before the roundtable discussions, I'll recheck to see if anybody else wishes to participate other than the main parties. And those sessions at the moment are on Friday afternoon, which is planning obligation and conditions roundtable session. And then Monday afternoon, the housing matters roundtable session. Can't see if I look in. The reserve session, sorry, that's on Monday as well. I was looking for, I'm thinking I've definitely put it in. The reserve session, that's on Monday afternoon as well, and that's for the matters. So that's quite clear in the programme. So I mentioned conditions and legal agreements there. So we will have a conditions and legal obligations session. That can be quite a dry session, and it can be very technical, because it's about, as the heading suggests, legal document to secure planning obligations, and also the wording and necessity of planning conditions should the appeal be allowed. Now, that discussion doesn't by any way, should not be interpreted that I've made up my mind. I need to be able to go away with a robust set of conditions and a planning obligation in the event that I was to allow the appeal, because the appeals process doesn't allow for, once I've closed inquiry, the inquiry is closed. So I need to go away with everything that I've got that I might possibly need. And as I say, that can be a bit of a it can be a bit of a dry session. So but we'll try and make it as painless as possible. So just in terms of, once we've heard all of the evidence and we've had the roundtable discussions, there'll be the closing submissions by the main parties. And that's scheduled at the moment for Wednesday, the 5th of October. Again, I've got, because this was meant to be an 8-day inquiry, there's quite a lot of sort of time. So if we need to, if that needs to be moved around, we can discuss that at the point. But there's probably enough time because we've got a reserve day on day 6. So although we're doing the site visit earlier, where the advocates would maybe be preparing their closings, we've the Tuesday is a reserve day, so that should hopefully help them out. I would like closing submissions to be given to be in writing beforehand, and that can be just before, you know, simply getting it to the case officer, so I've got it just for your opening. I shan't be reading it beforehand. I'll have lots of other things to do and I like to listen to it, but it just means that I can listen to it without having to make copious notes. So it would be, is that something that you both are able to do? And likewise, if you just share with each other just before you know the processes that go along. So after the closing submissions, I would intend to hear any applications for costs. Now, I know at the moment, neither of the main parties has indicated that they wish to pursue an application for costs. Obviously, that can change through the process. And as a, not to second guess anything, I always put it in as a contingency just in case we need that time. So you'll see that that is allocated on Wednesday, the 5th of October. Now, I'd prefer for those to be made in writing if at all possible, because again, it then allows me to listen to what's being said rather than concentrating on scribbling my notes. So that would be helpful if that were to be the case. And just for the benefit of everybody here, I do have the power to initiate costs awards myself, and that's principally if there was unreasonable behaviour through the course of the inquiry, the lateness of evidence which shouldn't have happened. You know, sometimes we end up with new documents, and that's mostly because I'll have asked for them. And I wouldn't obviously I wouldn't penalise parties for that, but hopefully we're not going to be in that position. I think so far we've had collaborative working between the main parties. I've seen evidence of that, so I'm not anticipating that I'm going to have to initiate anything at the moment. Does anybody have any questions before we move on to the site visit? Okay, so if you've read the programme, you'll see that I've made provision to undertake the site visit either this afternoon or tomorrow. Now, my initial proposal had been, and I think all of the discussion that we'd had up until Friday had been the visit would take place tomorrow morning. There was a last minute change to the program where I was hoping to be able to, instead of starting the evidence giving face to face and then finding that you had some witnesses that were giving evidence in person and others that were giving it virtually. I wanted it to be fair and that everybody gave their evidence in the same manner. So we were looking to have some of the round table discussions, but for various reasons I won't go into. I've decided that it wasn't going to be possible to do. We would have ended up with what we call a blended event, where some people would have been on a screen and some people would have been in the room, and these types of discussions don't work too well with that format. I think formal evidence given cross-examination works a lot better than a round table discussion on what we call a blended event. So I just want what I want is just for us to have the face-to-face today, and then everybody will be virtual thereafter. So the visit is a little bit weather dependent. I think when I came in, there's no windows, but there are windows here. It's not raining. It's not massively windy. So, and I don't think there's a bad forecast for tomorrow either. So I'm just wondering, really, from the main parties, sort of Pell and Council, what your preference would be, whether we do the visit this afternoon or we do it tomorrow morning. I'm easy to do it whichever way. I'm prepared whichever way we do it.
Thank you, Madam. Mr. Humphreys will be accompanying you, indicating he would prefer this afternoon. That's his.
Okay. Right.
We're entirely in your hands, Madam. If you wish to do it this afternoon, you will be accompanied by Ms. Symes. You have already an agreed proposed walking route, which is CD 11.3. We're conscious that Mr. and Mrs. Mead would like you to start, I think, a little bit further up Windmill Heights. We've got no objection to that whatsoever. And we think that it will take you, both the accompanied and I think the unaccompanied more remote sites, which you need to do, about 2.5 hours. We think that's probably the best estimate. So if you wish to do it this afternoon, then we can accommodate that, no difficulty. I should add that Mr. Howard is also going to come on that site visit to deal with sort of transportation matters if you need particular features pointing out.
All right, okay, so that's it. I'm going to speak to Miss Watkins in a moment about the request, but that's useful that we're all flexible to do that in terms of myself and the main parties. So as Mr. Litton's just said, the first part of the visit will be, which is like very site specific, that's going to be conducted as what we call an accompanied site visit, and that's where myself and representatives from the appellant and the council would be present. If anyone from from interested parties really wants to come along, then you're entitled to do that. It's just what I would say is that I do like to concentrate, and when I've got members of the public, it puts an extra responsibility on me to make sure that you're all safe, and it can, my concentration, I want to be able to concentrate and I'm sure you appreciate that I want to concentrate as much as I possibly can on actually looking, because I'm not really there to be listening to things. People can point physical things out, like such a junction or a hedgerow, but the purpose isn't to actually argue any case or anything like that. It is for me to see, and I've got a good idea of what I want to have a look at, and obviously I want to get a feel for the area. So that first element would be accompanied, and then I want to do a wider site visit, because obviously there's a landscape implications and highways where I want to go further afield, and that's just more practical that I do that on my own. So are there any other putting Ms. Watkins, your request just to one side first of all. Is there was there anybody who was wanting to accompany the main parties and myself? Okay, thank you. So in terms of, I had two specific requests from Mr. and Mrs. Mead, and also from Mrs. Watkins, to observe the site from their property. Now, in both the letters, I've got there's some photographs there that are very clear, and I think it's your relative, Mr. Miss Mead. I've got photographs from within their property there. I think it's their bedroom, first floor bedroom window that looks across there. That gives me a good appreciation of what they are saying to me. I'm not certain that it would be of any more help to go into the property to have a look at it, but I'm quite happy, and there is a potential, I should say, that we could go into the garden, maybe into the garden areas of both properties to look from that perspective. But I want to give the main parties a say in that before we decide what to do. I'll just bear a moment. Yes, sorry, Mr. Litton.
We have no objection. I mean, if you feel the need to go into the property itself, then you know, by all means, we have no problem. On the basis it's part of the accompanied site visit, there would have to be at least one person from the appellant and at least one person from the council that comes into the house at the same time. So as long as Mr. and Mrs. Mead, Mrs. Watkins is aware of that and they have no objection, then we're content.
Okay, and Mr. Atkinson, anything? Yeah.
I don't have a strong view.
Yeah. So what I propose we do is we will come to if it's convenient to do that today. Would that be convenient to do that today? We'll do that, but we'll not go in the property. We'll just from sort of the garden area. That'll just give me an idea. I appreciate the distance from the site, etc. I've got those photographs, and I do understand the arguments that you're making. Whether or not I agree with them is another matter. I can't say at the moment, but I understand it, and I'm able to make a visual assessment in the information. But it would be useful, I think, for me to have a look at it from those perspectives. Yes. Is it just about the site visit? Yes.
So I think the idea then would be to start at the top of the line. Which makes sense because there are a couple of views available to the public along Windmill Heights Road. So I think the programme suggests starting at bottom of Windmill Heights. So it's just a small.
Right, I'm with you when you say the bottom. Sorry, because obviously I haven't been yet. Well, what we'll do is if we meet as we were going to meet at the meeting point on the map, And then I'm sure that Mr. Humphreys will be able to take us to the relevant properties. Is that acceptable?
To the top of Windmill Heights. My sister's house is number 21.
Yes.
We can then go through the side passage into our gardens. And then I would suggest leave out a visit into Caroline's house, but I would invite you into mine because I just think, I know that there are photographs, but I think you get a really good sense of the topography of the land from my house. So I would suggest that. I think I have a couple of other comments on the plan, but I don't know if you want me to speak to those now or anyway.
In terms of,
yes. So
sorry, in terms of yes, in terms of the route.
yes.
Right. Okay.
So the group marked omits a section on the east side. I suggest you do walk along that because that takes you into the marshy valley. And then we'll take you up to the northeastern corner at the junction with Hunters Avenue. And there, I think it's useful to see there's quite a significant drop from the top of the field down to Kennel Lane. So, in short, I would suggest the entire perimeter is walked.
Right. Okay.
And then finally, I don't know how you plan to arrive there, but I would suggest you drive down Kennel Lane just to get a lane for
yeah.
its nature.
Okay, thank you.
And that's it.
Thank you very much. So I think at the moment where we're at 5:11.
Madam, sorry, can I,
Yeah.
sorry to interrupt. Just one slight wrinkle. Absolutely no issue with what Mrs. Watkins has suggested in terms of that. But this walking route at the moment is predicated upon the field access, which is a locked gate onto the A176 being open. And certainly we had made arrangements with the landowner that it would be open tomorrow.
Ah, right, okay.
We are just making inquiries now whether or not it can be unlocked so that you can get through that field gate, otherwise you have to climb over it.
Right.
This afternoon. Worst case scenario is that you might have to do a loop round the appeal site itself, come out and go down Kennel Lane and then along the public footpath up to the roundabout. But you might then have to retrace your footsteps because if that gate isn't open, you can't, as it were, get into the site from the roundabout or the A176.
Right.
So
okay.
perhaps we can just, I mean, it might add, 20 minutes or so to your site visit. But we will do whatever we can to endeavour that the gate is unlocked this afternoon.
Right, okay. But if it's not the end of the world.
It's not the end of the world.
Yeah.
It'll just take a little bit longer.
Yeah, okay. So I think I understand what has been said to me in terms of the additional stretch of route. So, but just Mr. Humphreys, Miss Symes, if you just keep us right when we're doing that. So if we'll come up to Windmill Heights first, then as we were going to, and we'll call into those properties first of all. And we'll look at the time there. Do you think 2 o'clock still a reasonable time to start? Just thinking about we're still, yeah. Okay, so it will be sometime it won't be before 2 o'clock, but it may be, if you're here, you're going to know what time that we haven't overrun anyway. So yeah, we can. Okay, and I also got Miss Lewis. Sorry, I can't. Sorry.
I was interested to know whether or not when you go beyond the actual site in your visit,
Yes.
whether it's seen that you don't just check them up there, that you don't go along Hipstars Lane. And I think it's quite important to actually look at the traffic flow there.
Yeah.
During the school, at the end of the school time, which will be 3 to, I mean, it starts before 3 o'clock. Some idea of the existing congestion now.
Yeah.
And,
Okay. No, that's fine. I mean, this is just for the accompanied bit. Where I go after that is I will go where I need to go in terms of I'll do an extensive. My visit will be extensive, and it'll be from a distance. It'll be from close up. It'll be I'll have exhausted it by the time I've finished, because I'm only here once, so I want to make sure that I've got everything that I need as well. So, but thank you for that, and I'm aware of all the comments about various junctions, and I know where they are, and I'll be having a look at, you know, at the appreciation of that as well. So thank you very much. So we've got a time. I think we know we're meeting at around where the star is on the map. And I think I asked this at the case management conference, that there aren't any health and safety issues that we need to be aware of. There's no mine shafts or just the normal. I mean, obviously walking along roads, etc., and narrow lanes, we know about that. But in terms of anything, there's nothing out of the ordinary.
No, it's an agricultural field, but I haven't been there in the last few weeks. I think it's reasonably dry. So
yeah, okay, thank you. Okay, so we've got that. Right. Okay, so just before we move on to the time estimates, just to check, there's no objections or concerns about the site visit at all from anybody. Okay, thank you. Now, just moving on to the time estimates. As I said earlier, I think the inquiry was scheduled initially for 8 days. But I think with the work that's been done on the common statements of common ground, the areas of dispute have narrowed somewhat, and we've arrived at a programme which is about 4.5 days, but we have got slippage time factored within that if it's required. Now, I've already been advised about people's availability, and I understand that, and obviously we've adjusted the programme today to make sure that we avoided what I called a blended event. I'm not aware, other than Ms. Symes, that there were any other time constraints at all. There's a date that I know with yourself, which we've managed to avoid. Nothing else. But if anything does crop up, because obviously we're still in a world of COVID, particularly. So if anyone is struck down with that, obviously it would, if you let the case officer know as soon as possible, it's going to affect your ability to participate. But hopefully a virtual format will help in that regard. And I've already asked everybody just to keep abreast of the programme on the council's website, so in case of any updates. And just to note, the virtual sessions will begin at a slightly earlier time at 9:30 in the morning. And the programme each day varies, but generally we'll have a break for lunch, short breaks in the morning and afternoon, and we will try to keep the virtual sessions short And if we need to put extra breaks in, we will do, to avoid screen time overload. Now, I'll be seeking assistance from both the advocates to find suitable times for the lunchtime break. I have indicated something that just works around the timings that you've both given us for the witnesses' evidence. So we'll try and stick to those. But if we need to change that, I'll look to you to help me come up with a plan for that. I'd like to really avoid overnight or weekend breaks in evidence giving. I think it's not a good thing to have done to you. If you're giving evidence and then it's a weekend and you've got the whole weekend to have it hanging over you. So I do try to avoid that if at all possible. Are there any comments on the programme from parties? No. So just moving on to the publicity and of the appeal and the planning application. This is just something that I need to do to make sure that we've got particularly with it being a non-determination case, that we've got everything that should have been done in terms of publicity has been done, so that I'm satisfied that no interested parties have been prejudiced by not being given fair opportunity to comment. So I've got a copy of the press notice dated the 7th of January 2021, and also a copy of the site notice which publicised, and both of those publicised the planning application. And I've also got copies of the consultation letters which were sent out. They were dated the 4th of January 2021. I've also got a copy of the council's letter dated the 9th of June 2022, notifying interested parties of the appeal being lodged. And I've also got a copy of the council's letter dated the 5th of September of this year, and that was to notify interested parties of this inquiry's date, time, format and location. And I've also got lists of who those letters were sent to. I've also got confirmation that site notices were posted near the site to publicise this inquiry. And I've got a copy of photographs of them in situ. However, I don't know what date they were actually posted because I couldn't zoom in far enough on the photographs. So I wonder if somebody can just confirm which date they were published. Obviously, you can come back to us on if you want. Yeah, I know it's been done. So I'll just ask, is the council satisfied that it fulfilled its duty to notify everybody it needed to, at least one method, and in line with their consultation strategy? I've also got a copy of a certificate C and the associated press notice posted by the appellant, and that's required for a situation where not all of the land ownership is known. And I just want to check, is the council satisfied that the correct notice has been submitted and it's all been publicised in the correct form? Can I just check, is it my understanding, is the bit of land that is outside that relates to certificate C, is that the bit at the top of the site, like the appendage? Yeah. Okay, so no issues have been brought to my attention regarding any of the publicity and that would prejudice or be unfair to interested parties. So I'm content to proceed with the inquiry on that basis. So I think, as I said earlier on, just moving on to the representations, I've got copies of all of the representations that have been made in response to the original planning application, consultation, and the appeal notification. And I just want to check with the appellant that you are content that you've had sight of all of those documents.
Yes, I mean, we've obviously got the documents at CD9, which are the application consultation responses, and at CD10, which are the appeal consultation responses. So we've seen those.
Thank you. And as I said earlier, just for everybody's benefit, I've already read these. I'll be rereading them on various occasions, and I'll be taking them into account in reaching my decision. Now, just on to the main issues. In this case, we don't have a decision notice. However, having read the evidence, which includes the council's punitive reasons for objecting to the appeal proposal, I'm now going to run through what I see are the main issues, and that's principally for the benefit of the interested parties, as the main parties are already aware of these. So firstly, the effect of the appeal proposal on openness of the green belt and its purposes, whether or not there would be other harm that would result from the appeal proposal. And this will include matters raised by the objecting interested parties, which are not in dispute by the council and the appellant. Whether or not there are other considerations which exist, and the weight that should be afforded to those. So that's when I'm balancing up all of the competing arguments for and against the appeal. It's imagine a set of scales, and I've got to come to a not a balance. It's got to go. It's going to tip one way or the other, and that'll include the contribution of the appeal proposal to boosting the supply of both market and affordable housing, and any other potential benefits that have been advanced through the evidence. And also, finally, whether or not any harm to the green belt by reason of inappropriateness and any other harm would be clearly outweighed by other considerations. And that's so to amount to the very special circumstances that would be required to justify the appeal proposal, with it being in Greenbelt, and with it being, it's agreed that it falls within the category of inappropriate development for Greenbelt purposes. Now that last main issue is all of the main issues are really, they're centered around the national planning policy current national planning policy on green belt, and there's a particular method that we in thought process that I must comply with. So the main issues are framed around that. So has anybody got any comments about these at the moment that I've missed something? Would be the principal one. Thank you. So now just on to the proofs of evidence, and I've just setting the statements of common ground to one side for now. I just want to check that I've got everything I should have in terms of the proofs of evidence and rebuttals. So for the appellant, Mr. Litton, I've got a proof of evidence and summary from Ms. Symes, and she's going to be giving evidence and be cross-examined in due course. So I've got that. I've also got a rebuttal from her as well on in connection with the council's evidence. Ms. Mulliner, again, I have a proof of evidence on what we'll term planning matters, and it delves into, she's also dealing with house and land supply. And you'll be being cross-examined in due course as well. So we've got the appendices, which is the house and land supply evidence, which principally should be taken as read, and it will assist in the roundtable discussion on housing matters. And we've also got the technical notes on affordable housing ecology, archaeology, flood risk, they're all appended to your evidence, and we've already discussed how we're planning to deal with that. A rebuttal
From
for
Mrs. Mulliner.
yes, I have got that. Yes, I've got that. Yes. And then we've got Mr. Howard, and I've got proof of evidence from him. And we've got him down on the programme to be given evidence in chief. And I think at the moment that's the way. I think that might be my preference, to be quite honest. If that's
Yes, absolutely. I mean, it was always our intention to call him, albeit that we don't think he's going to take very long in chief, because we are particularly conscious that local residents have a concern about traffic, and therefore it seems right that they have the opportunity to ask him questions, because he's the man to ask.
So I have his, and however, the council won't be cross-examining him.
As I understand it, no, it's
Yeah.
not an issue for them.
Yeah. Okay. And we've talked about the rebuttal statements. I've got that down. I jumped the gun. And in terms of the council, Mr. Atkinson, I've got a proof of evidence on alternatives planning matters, like planning and landscape, isn't it, from Mr. Humphreys, who'll be giving evidence on behalf of the council and being cross-examined by Mr. Litton in due course. And I've also got a proof of evidence relating to house and land supply from Mr. Davey on behalf of the council. And I think through the discussions, I propose that we take that as read, and we pick up any necessary questions through the roundtable discussion.
That's right, madam.
Yeah. And I don't appear to have had any rebuttal statements from the council. Is that correct?
That is correct.
Thank you. And I'll just something I always check, because it's always good to check. You've both got copies of all of those documents. Yeah. You'd be surprised if you don't ask it. The day that I don't ask it, it'll be the day that somebody won't have it. And just for the benefit of everybody else who interested parties there, I've read all of those proofs of evidence. Again, I'll be rereading them as we go through the evidence and thereafter. So I'd expect them to be taken largely as read. Now, just moving on to the statements of common ground, I just want to check that I've got everything there as well, because obviously they came in at different times. So I've got what I'll call the main statement of common ground, and that was signed electronically and dated the 9th of September 2022. I've then got the housing land supply addendum, which I'm taking as being part, like a statement of common ground document, and that's been signed electronically, and that's dated the 9th of September as well. I've also got a landscape and visual statement of common ground, and that's been signed electronically, and that's dated, it was the 9th and the 12th, because it was signed on different days by the main parties. And I've also got a highways statement of common ground, which is signed as well. And they are all the statements of common ground that I've got, and I just want to make sure that they're the most up-to-date versions, and that I've got them all, and that you have them all. Well, you should have, because you've signed them.
Yes, madam, and just really for perhaps interested parties, they are called documents as well. The main statement of common ground on planning matters is called document 7.8. And the addendum which goes with that is called document 7.26. The highway statement of common ground, which is signed with Essex County Council as the Highway Authority, is CD 7.9, and the landscape statement of common ground is CD 7.10.
Thank you. And obviously, if you haven't already had a look at those documents, they might be helpful for you to have a look at, and you can pick those up from the council's website. I've also got confirmation that came through an email on the 20th. I received it on the 21st September. I think it came through on the 21st. I certainly received it on the 21st. And that was in respect to affordable housing, and that the dispute, my reading of that email was that the disputed matters in relation to affordable housing have been resolved. And I've noted that on my, I know that it changed some of the numbers on the figures on the tables, and I'm aware. So I just wanted to check that that's my understanding, that in terms of, other than weight, in terms of figures, there isn't anything outstanding on affordable housing. Yeah, it's more the weight that we give to it. Okay, so turning to the planning obligations, I'd just like to check that I've got the most up-to-date SIL compliance statement, which was provided by the council, and also the current draft section 106 legal agreement. And they were both submitted to me on the 22nd of September this year. I just want to check that I've got the most up to date.
That's my understanding. I've got certainly the SIL compliance statement is dated the 22nd, and you were circulated draft section 106. I think there have been further discussions with the council in relation to some of the outstanding matters on the section 106, but they are relatively minor, I think, related to definitions rather than
right, okay,
substance. So
because that was going to be my next question, really. It was in terms of understanding where we were in finalising it, because what I know that I think the main parties has indicated that it could be 2 weeks after the inquiry closes. What I need to make sure is that that any disputes have been resolved before we close before I close the inquiry. If it's a case of just it's the practicalities of getting it signed and it needing to go to different people, that's fair enough. I can permit a period of time for that to be submitted. But if we're at a point where we need to be at a point by close that there isn't anything outstanding, there isn't anything outstanding. Otherwise, if I close, it leaves me in a very funny position.
Yeah, no, we understand that, Madam. As I say, I know that there are some still ongoing discussions, and I expect 99% of those to be resolved. And to the extent that there are matters which remain in dispute, they will be clear and they will be a matter of discussion, the Section 106 agreement. And it may be that you are going to have to take a decision on those matters in dispute, but you'll be aware of what they are and you'll be able to take a decision. I mean, I can say, for example, there is a discussion and probably a dispute as to whether or not a bus contribution is still compliant. We are of the position that it's not. The council says it is. There is a blue pencil clause in the Section 106 which would allow you, in the event that you decide that it's not still compliant, to strike it out. Okay, thank you.
Because that's the highways authority that's taking that.
Right, okay. And there's be somebody there at that session, won't there? Yeah, I think
we are proposing to have Mr. Smith, who is the solicitor responsible for drafting that, and Mr. Howard to explain why we are not convinced that it's still compliant.
Yeah.
I don't know what the position of Essex County Council is, whether they're proposing to attend or not.
Yeah, but that's the main sort of area. Right, okay. So hopefully we'll get to a, but I just wanted to put that marker down that that'll be where we need to get to, because I can't have things hanging over. And in terms of the 2 weeks, it's a little bit longer than I would normally give. That would be very much on the generous side for me. One of the things is I've obviously got my I've got things to do once the inquiry closes. I have other commitments, and I've got time programmed to write my decision. So I like to have everything, and we've got targets to try and make sure that as customers, you all get the decision as quickly as possible. So, it all links in. So a week would be more palatable for me.
Yes, Madam. I think we asked for 2 weeks as a sort of a long stop. Obviously, if we manage to get it formally executed earlier than that, we'll send you to you immediately. We're not going to wait, sign it on day one and then wait 14 days to send it to you.
Yeah, no. So we've got this time between now and that session, and thereafter we'll get that position. So just turning to conditions now, you'll recall that on the 22nd of September, I issued some queries that I suggested it would be prudent for them to be dealt with in advance of the planning obligations and conditions session. I'm not expecting that you maybe have done that work yet, but I'm just wondering, you want to check that A, it was received, and B, how that work's progressing.
No, it has been actioned both by the council and ourselves. I think we independently, the council and the appellants independently looked critically at the conditions in the light of your comments, and then exchanged their revised conditions, which have now been merged, and I think agreed between the parties. I'm not sure whether you've been sent that agreed position. If not, it will be sent to you very soon. Right, there are apparently a couple of minor disagreements between us and the council. We're going to iron those out and send them to you ASAP.
That's lovely. Do appreciate that. I did give you there was a warning. I think I did give you pre-warning on during the case management conference about conditions and yeah. Oh, yeah. But that will help the session immensely, because as I said earlier on, it's quite a dry and technical session. It's probably the one that it's probably people's least favourite. If you like a good inquiry, it can be not the best. So that will help. Thank you very much. And I just ask that if there are any additions to the core document list, that the website is updated as soon as it can be, hopefully by the end of each day. But I do know that sometimes council's websites need some time to refresh, or you might be relying upon the IT department or some process that you have in place. It varies between councils, but just as soon as you possibly can do, so we can keep that list up to date. And any documents that are submitted from now, I'd like those to be inserted in that list under the heading inquiry documents and be given an ID reference rather than a CD. So it would be ID1, ID2. And that just helps distinguish between document types. I'm not inviting any further evidence. However, does anyone intend to submit anything now? Because it would be good to know. So that's Mr. Lynn.
Yes, Madam. There are two documents that I'm going to ask be put into the inquiry. Neither of them are relevant to today's sort of sessions. But let me just identify them for you, please. One is a decision letter dated the 23rd of September by a colleague of yours allowing an appeal in relation to the Eastgate Centre in Basildon. You may be aware of it already.
I haven't read the decision, but it was something that I was going to pick up today because I hadn't had an opportunity to check, and I thought it was more fitting that I checked in this setting.
So, I mean, it's obviously relevant, particularly in relation to housing land supply. I appreciate it was a town centre site, not a greenbelt site, but nonetheless, housing land supply was an issue. And so the conclusions reached by your colleague in relation to that are of some significance. So we'll look to introduce that. And what I propose is that we circulate that document electronically through Ms. Charles to yourself and obviously to the council, who will be fully aware of that. And then the second document actually comprises sort of a part A and a part B, and that they are the statements of common ground that were entered into between the appellant and the council in relation to an inquiry which finished at the end of last week, I think, called Maitland Lodge, which is a partially a greenbelt site within this borough on the outskirts of Billericay. And again, there's some agreements that have been reached in relation to the main planning statement of common ground, but also the statement of common ground entered into with the Highways Authority, which will be relevant to the evidence. So those are the two documents that we would wish to introduce, and we would circulate. Well, we're in a position to circulate them now if you're happy to accept those. Clearly, they are both documents that are very recent.
So that's the reason why
Yes,
they've come in
yes.
late. They're effectively
Yeah,
late. But
I mean, they
it's-
would say,
it's-
yeah.
yeah. And there are things that could be certain, there would be time for them to be digested. Are the council's aware of them anyway?
Yes, we'd circulate them now. Obviously, they're not relevant until we get to Thursday's business. So there's, at least a day and a half for people to have an opportunity to look at them. As the council clearly is aware, because they were party to both the inquiry that finished last week and the inquiry that resulted in the Eastgate appeal being allowed.
Mr. Atkinson, I'll just ask you for your opinion on.
Yeah, just so that I've understood, you said through you, Madam.
Yes,
my
that's
friend asked for to be part A and part B. So part A is the general planning statement of common ground from Maitland, and part B is the highway.
Is the highways correct? Yeah.
Well, Madam, clearly they are documents which are known to us. I mean, query the relevance of the general planning statement of common ground for another site, but it's something which has very recently come to light. So in that sense, I don't object to them going in.
Okay, well, I'll permit those to be on the basis that they are relevant. I'll trust that they're relevant.
Yes, we're not going to spend huge amounts of time on them,
Right,
but there are
you.
a couple of points that are relevant.
If they could be circulated, and they'll need to be put onto the council's website as the inquiry documents.
I don't want to give them the inquiry document just yet, Madam, because I suspect that my opening statement is going to be ID 1.
Ah, right, okay, yeah.
And then
okay.
perhaps Mr. Atkinson's ID 2, and then
Yes.
they might be ID 3 and 4.
Yes,
But if you're happy with that.
I'm absolutely fine with that, yes. Anything else in terms of evidence? Okay. If there is anything that crops up, obviously, again, it's sooner rather than later, draw my attention to it, and then we can decide what we do with it. So I've just got, before I conclude on my own, because I have overrun on a little bit, quite a lot. These things are always a little bit of an unknown. In terms of clarifications, I've just got a few clarifications that I could do with just now. So the first one, I think this is really for Mr. Atkinson for the council. So since the main statement of common ground was prepared, have there been any changes to in the CMC as well? Have there been any changes to the progression in the emerging local plan or any relevant neighbourhood plans? Is there anything, in terms of development plan, the status of it, anything that's come along?
Yes, actually, the LDS on the Thursday, and it was approved there. It's still has to be ratified by full council. And that's due to take place in November. Yeah. So
Okay.
progress is being made.
Okay, and there's no neighbourhood plans for the area being made or anything in the meantime. And this is just a point in relation to the saving direction for the as in the local plan, the current local plan. From my reading of all of the documents, it would appear that you haven't been able to get your hands on the saving letter, the original letter that confirms which policies were saved.
The original letter, we can put it in the same process document as the intro with the letter, but we don't have the original.
Right, okay. But I just wanted to check that all part you're absolutely happy with what was saved and what wasn't saved.
I mean, yes, I mean, I think we have tried to get hold of the actual saving letter itself, but have failed, which is why I think we put in examples of saving letters, but no one's been able to, possibly because it's so old.
Don't say that. I remember receiving the letter just like that.
I could tell you a story or two about that.
But yes, so I just wanted to check that obviously we're going to have to work on if we're working on that basis that there isn't any dispute in regard to that. Okay, that's it. And I understand the points that have been made with the substitutes that have been provided. Okay. And then I just want to check what the up-to-date position is, status of the saved policy, consistency with the NPPF, National Planning Policy Framework document. I think that was going to some a cabinet meeting. I think we talked about it. So has that now been agreed? Not yet. So do we know when it will be agreed? So does that get ratified through the full council? Or? Right, okay. And that update, my understanding is that would update a previous version that you had.
The last iteration, it's just 2021.
Yeah. Yeah. I just want to check that the plans that I am looking at are the plans that were listed in the statement, the main statement of common ground. There haven't been any changes or substitutions or anything in that regard. Okay. And in terms of the SIL compliance statement, I think there was a little bit of dispute over that. Is that the issue, the bus contributions issue that we were talking about?
Yes, madam.
Yeah, it's linked to the same. It's linked to the Okay.
Yes, I mean, obviously the civil compliance statement was produced by the council.
Yeah.
It hasn't been produced, but with any input from us, I don't think, but you're right that we are concerned about the.
But it links. Yeah. So that's what the issue is. Yes.
The county council still compliance statement isn't been looked at because that's the position with regard to the plus contributions.
Right. Okay.
Ours is progressing, and we've just got the position with regard to the county council.
Right. Okay. So hopefully we'll get to it. We'll get to a position when we get to that the planning obligation session where. Okay.
Sorry, madam, I should, I suppose, formally introduce Mrs.
Sorry.
Lyons, who you're communicating with, his head of planning here, Christine Lyons.
Okay, so that concludes my opening remarks. So we're now, we are a little bit further behind than the programme, but these things are necessary. If we can now move on to the openings, unless anyone wants a short break. Anybody need a short break, or are you quite happy to just continue?
No, I have to continue, madam.
So we hear both of the openings and then from the interested party. So
And we have circulated these electronically shortly before 10 o'clock to the case officer at Pins, and also coming into the council. We have some hard copies here
lovely.
for.
Do you have it? Is there a copy for me?
Yes, it's
Oh, thank you. I'll meet you halfway there. Thank you very much. Thank you.
So, madam, I should just explain what I've handed to you.
And indeed to the council. So there is a 6-page opening statement, and attached to that is a case summary of a case which I suspect you're well familiar with, Hallam Land Management. And I have provided to you a full copy of the judgment as well.
Yeah.
So I'm not proposing to read either the summary of that case or the case itself, but so that you have them in their entirety. And all I am going to do is read, for the benefit really of third parties, from my written opening statement, which no doubt will go up on the website. And should we give that ID 1?
Yeah.
So if you're happy, madam, I
Yes.
will start. This appeal arises because of Basildon Borough Council's failure to determine an application for outline planning permission, save for the access, submitted by the appellant, Gleeson Land Limited, for the construction of up to 200 dwellings, I should say at least 36% affordable housing on land north of Kennel Lane, Billericay. Although the appeal is for non-determination, the council resolved on 6th of July 2022 that had the council been able to determine the application, it would nonetheless have refused it because it is inappropriate development in the Greenbelt, and there are or there were no very special circumstances to outweigh the presumed and actual harm to the Greenbelt. A second reason for refusal relating to the absence of a Section 106 agreement, we say will be resolved by the appellant submitting a unilateral obligation, the contents of which are largely agreed, and we've had discussion about that already. The appeal site, as agreed in the planning statement of common ground, comprises a large grass field in agricultural use in the Greenbelt on the edge of Billericay. It's further agreed with council that the appeal site is in a sustainable location and is, and I quote, well related to the urban area and benefits from a high degree of containment with substantial hedgerows and tree belts along each boundary, end of quotation. A public right-of-way runs along the appeal site's northeastern boundary connecting Windmill Heights and Hunters Avenue. The proposed access will be via a new arm off the Langdon Road, A176 and Noak Hill roundabout. Other than being in the Greenbelt, the appeal site is not subject to any landscape or other statutory designation. There are no heritage assets on the appeal site or in the immediate vicinity, which would be affected by the proposed development. Billericay is a substantial settlement with a wide range of services and facilities, including a railway station, and it is agreed with the County Council as the highway authority that the appeal site is in, and I quote, a sustainable location to encourage travel by walking, cycling and public transport, close quotation, see the transport statement of common ground. It is a 15-minute walk from the appeal site to the centre of Billericay and its wide range of everyday facilities and services. The railway station is a 21-minute walk or a 7-minute cycle ride or 20 minutes on the bus from the appeal site. An infant junior school is within a 6 to 8 minute walk, and a secondary school within an 11-minute walk of the appeal site. Again, see the transport statement of common ground. South Green, to the south of the appeal site, is an even closer local centre. It also provides a good range of facilities and services needed to meet the everyday needs of residents and is an easy 10-minute walk from the appeal site. The development plan comprises only the Basildon District Local Plan, adopted in 1998, 24 years ago. To say it is long in the tooth is an understatement. Because of its age, it was necessary for the Secretary of State in 2007 to issue a direction saving some of the policies in that plan. Of particular relevance to the present appeal is policy BAS-GB1, which defines the extent of the greenbelt within the district. The greenbelt boundaries were first established in the Billericay Local Plan adopted in 1989, 33 years ago, and were not reviewed in the Basildon District Local Plan. Moreover, GB1, policy GB1 records that the greenbelt boundaries were drawn up with reference to the then long-term expansion of the built-up areas. As a matter of fact, greenbelt comprises some 63% of the district. An issue for the inquiry is whether policy GB1 is consistent with the NPPF, given that it sets the greenbelt boundary within the district 33 years ago and is a significant constraint on the council's ability to deliver the levels of market and affordable housing required. The council started work on a new local plan in December 2014 and published the Regulation 19 draft in October 2018. The draft local plan was then submitted for examination in March 2019. The draft local plan did not seek to meet the district's housing need in full, and in December 2020, the examining inspector questioned the council's approach and sought justification for the underdelivery of housing. This led to modifications being proposed, which the relevant committees recommended should be adopted by the full council. However, and notwithstanding the advanced stage it had reached, the council withdrew the draft local plan on the 4th of March 2022. Prior to its withdrawal, the draft local plan had proposed releasing the appeal site from the Greenbelt and allocated it for housing development, allocation H18, known as land south of Windmill Heights. Having been identified as suitable for housing by the council's Greenbelt review in 2017, the landscape appraisal at the same time, and the sustainability appraisal in 2018, together with the HELA in 2020. Whilst plainly not part of the development plan, the proposed release from the Greenbelt and allocation of the appeal site for housing, together with the evidence base, are plainly material considerations in the determination of the appeal, which support, we say, the appellant's case. Other than being in the Greenbelt, the appeal site is not subject to any landscape or other statutory designations, and there are no heritage assets on the appeal site or in the immediate vicinity, which would be affected by the proposed. Sorry, I should jump back. I thought I was repeating myself. Apologies, madam. Over the page, it's paragraph 13, housing land supply. It's agreed that the council has a severe shortfall in its 5-year supply of deliverable housing sites. On the council's case, the 5-year housing land supply is no more than 2.3 years, and on the appellant's case, it is as low as 1.76 years. See the addendum on the 5-year housing land supply position. In the very recent appeal decision dated the 23rd of September relating to the Eastgate Shopping Centre in the centre of Basildon, the inspector concluded that the 5-year housing land supply would be, and I quote, around 2,470 dwellings or close to 2 years, close quotation. It is further agreed that the severe shortfall will persist even if the present appeal is allowed. See the addendum to the 5-year housing land supply document. It is agreed that the council has, and I quote, performed poorly in all housing delivery tests to date, close quotation, with delivery being 44% and 45% of its requirement in 2019 and 2020 respectively. In the latest year, 2021, it has fallen further to 41%. The delivery of affordable housing is worse still. In the 5 years from April 2016 to March 2021, it has delivered at most 118 affordable homes against a requirement of 1,955, 6% of the need. If the right to buy net delivery position is taken into account, that figure falls to 45 affordable dwellings, 2% of the requirement. Moreover, although the council has published successive action plans to explain how it proposes to address the shortfall, the reality is that until it adopts a new local plan, there is little or no prospect of the council being able to make any real progress in addressing the shortfall. And on the council's most optimistic basis, a new local plan will not be adopted until the fourth quarter of 2027. See the council's LDS, which was agreed on the 8th September, and as Mr. Atkinson has said, was approved by Cabinet on the 22nd of September, and is going to the full council on, as I understand it, the 17th of November. The magnitude of the shortfall, how long the shortfall is likely to persist, what the council is doing about it, how much of the shortfall proposed development will meet are all relevant to the weight to be given to the benefits of new housing development. And the footnote there, Madam, refers to the Hallam Land Management case, which has the case summary attached, and then the full judgment. The absence of a 5-year housing land supply triggers paragraph 11D and footnote 8 of the NPPF, the framework. This means that the policies most relevant to the determination of the appeal are deemed to be out of date and the tilted balance applies. However, because the appeal site is in the Greenbelt, paragraph 11D1 is relevant, such that planning permission should be granted unless the protection of the Greenbelt provides a clear reason for refusing the development proposed. The council, in promoting the revision of the Greenbelt boundary and the allocation of the appeal site for housing, was clearly satisfied that there were exceptional circumstances which justified its release from the Greenbelt. However, because the council has withdrawn its emerging local plan, the appeal site remains in the Greenbelt and the proposed development is inappropriate development. It is therefore necessary to show that there are very special circumstances which clearly outweigh the potential harm to the Greenbelt by reason of its inappropriateness and any other harm arising or resulting from the proposal. Other than the alleged harm to the openness of the Greenbelt and some of the purposes of the Greenbelt, the council does not suggest that the proposed development would cause any other harm in its reasons for refusal. Whether the putative reasons for refusal, whether the proposed development will adversely affect the openness of the Greenbelt and or its purposes, and if so, how much, is one of the main issues in this appeal. The appellant's case is that inevitably there will be some harm to the openness through the development of the appeal site, but the harm is limited to the appeal site itself, and there will be limited harm to one of the purposes of the Greenbelt and or to the character and appearance of the area. Save for these, there is no other harm. It is also the appellant's case that the limited harm to the Greenbelt is clearly outweighed by the substantial benefits of the appeal scheme, and that there are very special circumstances. In particular, the appellant relies on the age of the Basel District Local Plan 1998 and the inconsistency with the framework of the safe policies relevant to this appeal. The glacial progress of the council in progressing and adopting a new local plan, the severe shortfall in the 5-year housing land supply and woeful delivery of both market and affordable housing, the absence of any realistic plan to address the shortfall in the short or even medium term, and the sustainability of the site is demonstrated by its allocation in the emerging local plan for housing. Taken together, we say there is a compelling case that there are very special circumstances which justify permission being granted for the proposed development, notwithstanding its location in the Greenbelt. And so, Madam, that's all I propose to say by way of opening, unless there are matters which you would like me to address.
Thank you, Mr. Litton. I won't have anything that I need you to
No.
address. Thank you.
Thank you, Madam.
Mr. Atkinson. I'll meet you halfway again. So if we take this as ID 2. When you're ready, thanks.
Madam, the issues in this case, as between the LPA and the appellants, are narrow in the sense of them being concerned only with harm to the green belt and to the character and appearance of the appeal site. But at the same time, they are critically important in the sense that what is proposed is the development of a large open field in agricultural use in the green belt. The appeal site is currently completely open and free of development. This is not a case, for instance, where there is any sort of foot in the door, so to speak, for development in the shape of previously developed land. It is an open field. This is reflected in the acceptance by the main parties that the proposals are plainly inappropriate development in the greenbelt. Definitional harm, harm to the purposes of safeguarding the countryside from encroachment, and harm to openness in this case are all agreed, and all must be given substantial weight in the final balance. The council maintains that harm flows to the purposes of checking the unrestricted sprawl of large built-up areas and preventing neighbouring towns from merging into one another, purposes A and B, notwithstanding the findings of the 2018 Greenbelt topic paper. The question for determination at this inquiry does not occur in a vacuum, however. By withdrawing the emerging local plan in Basildon, democratically elected members of the council have made a clear statement about planning for the future of the green belt in Basildon. The statement of withdrawal set out the following reasons for the council's decision. The reason for withdrawing the plan was that the council wished to pursue a different spatial strategy to that set out in the submitted local plan, particularly in respect of the use of greenbelt land to meet the needs of the borough and neighbouring authorities. This is the background to the council's decision, expressed in its putative reason for refusal 1, I should say, which should not be overlooked at this inquiry. That is not to say the council is ignoring its responsibilities to identify sites for housing through the plan-making process, and steps are being taken towards that end currently, with the publication this month and the approval by Cabinet of the BBC Local Development Scheme 2022 to 2027, the stated aim of which is to inform the public and stakeholders about the local development documents for Basildon Borough and to set out a suitable timetable to prepare or review these documents and at what stage people can expect to be involved in the plan-making process. The LDS envisages issues and options consultation, Regulation 18, at the end of this year, Q4 2022. It would be foolish of the council not to acknowledge the benefits of the additional market and affordable housing, which it does, and gives appropriate weight to these important factors, in addition to the other benefits argued for. But overall, careful analysis of the evidence will confirm that the council's putative decision, to refuse permission was the correct one. It is for these reasons that in due course, I shall be inviting you, Madam, to dismiss this appeal.
Thank you. There's nothing that I need to address at the moment.
Thank you.
As a result of that, thank you very much. Okay, so that concludes the openings. And now whether we want to do we want a short break and come back to Councillor Moore, or Councillor Moore, are you happy to address the room now? Anybody need a break, or will we? I'm happy to
No, I'm
continue.
happy to move on, Madam,
Yeah.
you are.
Where would you like to, do you want to be where you are? Do you want to come down? Yeah. I wonder whether Mr. Atkinson, are you getting some water for?
Well,
Oh.
getting on myself.
Sorry, could somebody get one?
Yeah.
No, sorry, it was unintentional. Thank you very much.
There's Jim in there.
Just before council.
I was going to sit here, but I thought-
Oh no, it's fine. I'll just ask first of all, how long do you think you're going to be? I don't want to appear, I don't want that to appear rude at all. It always don't mean that. In how long do you need? All right, okay. That's
And can I just clarify? I don't believe that there's anything from Mr. Moore in terms of representations either to the application or to the appeal. If I'm wrong on that, would he correct me?
You're correct.
Right, thank you.
Okay, shall I?
yes, if you want to just begin in your own time.
Thank you. Yes, I'm Councillor Richard Moore, and I'm one of the ward councillors representing the Bursted ward. The application site is within the Bursted ward. I've lived in Billericay for 45 years and have lived in the Bursted ward for the past 20 years. I've been a Bursted ward councillor for the last 18 years and represent some 10,000 residents in the ward. I am very familiar with the application site, which is in fact located at the end of Langdon Road, where I live. The application proposes 152 houses and 45 flats. The proposed houses would be 2 stories in height, and the houses would be a mix of detached, semi-detached or terraced. The proposed flats would be contained within several 3-storey and 2.5-storey blocks, excuse me, situated around the proposed estate. This area of Billericay has no 3-storey or 2.5-storey blocks of flats, with the consequence that these buildings would be out of context with the surrounding area and would be visually intrusive to the onlooker. In the community consultation held by the applicant in July 2020, in the middle of the COVID pandemic, there was no mention of blocks of flats. And I assume, Madam, that you have a copy of the community consultation in your document pack. The planning officer's report to the planning committee of July the 6th this year outlines in some detail the landscape character of the application site. I'm sure that this landscape will be viewed during the proposed site visit this afternoon. Local residents appreciate the openness of the area and are concerned that the openness of the site would be lost forever. In terms of the green belt, the inquiry needs to appreciate that Billericay is surrounded by land designated as green belt, and Billericay residents are passionate about protecting what they consider as their green belt. Any proposal to build on this green belt is in fact met with fierce opposition. The site provides some of our best and most versatile farmland in the area, and at a time of global food security issues, it would be perverse to lose this resource to housing. If this application goes ahead, this farmland would, of course, be lost forever. The application site makes a positive contribution towards 3 of the 5 purposes of including land within the green belt, and local residents believe this land should remain in the green belt. Residents appreciate the visual amenity provided by the site, which would be lost to future generations if this application goes ahead. In terms of flood risk, The surface water strategy proposes to use SUDS infrastructure, including surface water attenuation basins. The submitted flood risk assessment concludes that there is a low risk of flooding from all sources at the proposed development. However, there is an existing problem of flooding some 400 metres to the south, near the junction of Kennel Lane and Church Street. This is caused by water runoff from the application site and from the fields south of the application site. Billericay had severe flood events in this location in 2011 and 2014, where residential properties were in fact flooded. There was a proposal some years ago to develop a flood alleviation scheme close to the flooded properties in Kennel Lane, which consisted of 2 attenuation basins and other measures. Unfortunately, this scheme was never implemented. The proposed development will only exacerbate an existing flood risk problem and would need to be addressed more fully. There are 2 brooks on the application site, and the proposal shows development on the eastern side of the valley. It would appear that both sides of the site need to be free of housing in order to effectively manage water runoff. The developer needs to be aware that this end of Kennel Lane regularly gets flooded after heavy rainfall. We're not convinced that the surface water drainage scheme is robust. And, Madam, if the application did go ahead, residents would expect a sound flood alleviation scheme that adequately addresses the concerns I have outlined. I'm not obviously an expert on flood management, but my residents and I fail to see how the planning officer's report could state that the proposal has adequately demonstrated that surface water flooding can be effectively managed. I hope that this matter could be more fully explored in the future. Now, the impact of the proposed development on Billericay, there are 2 doctor's surgeries close to the application site. These are Chapel Street Surgery and South Green Surgery. Both of these surgeries are oversubscribed. The introduction of a further 400 plus patients is not supported by the NHS. A new doctor's surgery would be required. There are 6 dental practices that future residents of the proposed development could access. However, few of them are taking on new NHS patients. In terms of schooling, Billericay has 10 primary schools. The entire physical capacity of the primary schools in Billericay is 3,073. The forecast for reception places in Billericay's primary schools shows a deficit of places over the next 10 years. This application will only exacerbate primary school capacity in the Billericay area. Basildon Borough has 9 secondary schools, of which only 2 are located in Billericay. The capacity for secondary school places shows that secondary schools in Basildon Borough have capacity, but not necessarily in Billericay. The application site is in fact adjacent to Billericay School, and it would be perverse if children from the application site had to attend a secondary school in central Basildon. You've already heard a little bit about the traffic problems around this area. The road infrastructure around Billericay is already running over capacity, with queues going from the High Street to the A176 roundabout at Kennel Lane at certain times of the day, mainly between 7 in the morning and 9 and 4 in the afternoon to 6:30. Many motorists use Kennel Lane as an alternative route when they see the A176 is blocked. The introduction of further traffic from a new housing estate would exacerbate an already overburdened road system. I'm surprised that the Planning Officer's report for the July 6th Planning Committee suggests that the highway mitigation and enhancement measures proposed would not result in the impacts on the road networks being severe. For those of us living in Billericay, an additional 400 plus vehicles onto the local road network would exacerbate an already overloaded road network. Kennel Lane itself is a country lane. It is highly unsuited to the increase in traffic the proposed development could bring. Kennel Lane, at the location of the application site, is very narrow, it's winding, very rural in character, and has a blind summit. Again, I am surprised that the Highways Authority makes no mention of the additional traffic on Kennel Lane, Hunters Avenue and Langham Crescent, and the unsuitability of Kennel Lane for increased traffic movements. During your site visit, I recommend that you actually drive along Kennel Lane from the A176 roundabout and see for yourself the unsuitability of this road for any increase in traffic. Finally, Madam, I and my residents are opposed to this application. So thank you for the opportunity to speak.
Thank you. Could I ask you a question? Are you happy to answer a question that I've got? It's just in relation to your statement about the flood risk assessment and its robustness. What precisely is the concern about its robustness? Is there something particular that
In terms of the proposal?
Yeah, in terms of the, I think I've noted down, yeah, find it. That you had, that it wasn't robust.
Yes.
It was just if there was anything particular, that any particular reason why you and the residents think that it's not robust.
Because we do not believe that the proposal has adequately demonstrated that the surface water flooding can be effectively managed. It's already a problem today, and we're not convinced that the two attenuation basins that are in the proposal will actually resolve, first of all, the flooding at the end, the southern end of Kennel Lane, where residential properties in the past have had inundations to their properties, and also to Kennel Lane itself, adjacent to the application area, where when we have heavy rainfall, it is regularly flooded.
And that's where, is that where I've read where there's mention of two brooks? Is that, is it in that the area of those
Yes.
two brooks?
Yeah.
Right, okay. Thank you. Yeah, it just clarifies it. Thank you.
I do have some questions. Yes, please,
are
madam.
Are you happy to take? Thank you.
Morning, councillor. Oh, possibly afternoon, councillor. I think you confirmed earlier when I asked whether or not this was you made any representations to the application or the appeal itself, and you said no. Is there a reason why not?
Yes, my colleague, Bursted Ward Councillor, had made a representation, which the three ward councillors fully supported.
Right, and sorry, who's that?
That would have been Councillor Andrew Baggott.
Right. Okay. Secondly, I mean, the concerns that you've expressed today, you know, particularly in relation to flooding and your criticisms of the officer's report and the position of Essex County Council, have you taken those matters up with either the council or the county council?
Those matters were explored in the planning officer's report.
Yes, I know, but you've been critical of the officer's report and the position taken by the county council. My question to you is, being critical of those matters, have you actually taken the opportunity to speak to the officers and or the county council to raise your concerns?
I have not.
No. All right. And then just lastly, I know I can see you read from a script. Could we possibly have a copy of that, please? And then we'll just double check that we have tidied off, as it were, everything in there in terms of our response. Thank you very much indeed.
Thank you. And that would be, it would be useful if we could have the if we could have a copy of that, and then it'll go on record, and it's I've made notes, but it'll mean that I've got an absolute carbon.
It's been updated.
No, that's fine. Is it something that it might well be that you need, if it's a hard copy, you might need to scan it in, or
Shall we call that ID3, madam?
yes, yeah. Before we move on, Mr. Atkinson, is there anything from your, no, you're okay. Yeah, okay, thank you. Thank you very much for your time, and thank you for your patience in waiting for us to proceed, and that's really helpful. Thank you very much. Okay, so that, looking at the programme, apart from any housekeeping we've got, but I think we've been pretty good. We've kept that up to date as we've gone along. So there's nothing really to I always like to have a little housekeeping session in the programme, and then it just means that if anything, it's a prompt for me to remember things that we've agreed or to do, etc. But we haven't got anything at the moment other than to keep the core document list up to date. So that's fine. So the only thing we now is, I think we're back, like remarkably, we're back on into time on the programme. So amazing how you can fall behind then catch back up again. So that's it's all good. So I think if we can just double, do we have a position with the gate? Will I be climbing over a gate, or will we be? It's open to be open, yeah. I'll take a view on, if it's not open, I'll take a view when we get there as to whether I wish to climb over the gate, because experience has taught me not to be over optimistic. So there you go. But I think I managed to climb over it. So I think we've got a route, and we know that we're going to be joining at the where we've got the star marked on it, will Windmill Heights, and then we're going up to the two properties. Yes, and Mr. Humphreys, you know where they are, yes. Yeah, to direct us there, and then we'll have a look at that. I'll take a view as to whether I feel I need to go into your home at that point. I'll know when I get there whether I do or not, so that's fine. But don't read anything into that either way, as long as you know that. And then we've got the route, and we've got plenty. It looks as if it's. I see a bit of sun out there, possibly some blue sky, so I think we're okay. If everybody else is happy with still this afternoon, we can do that. So with that, I propose that we meet Is 2 o'clock on at Windmill Hill? Is that going to be? Is that okay, or do you want 2:30 or 2:15 or 2 o'clock? Fine. 2 o'clock fine with yourselves? Yeah. Okay. And that should give us enough time because it's still not. We've still got. I can't remember what time it got dark down here. Yeah, I think we're a bit. Yeah, it's a little bit. It's a bit quicker up north now, so yeah. Yeah, we've got plenty of time to do that. So it'll be Mr. Humphreys for the council, Miss Symes, Mr. Howard, and myself, and then we'll come up to your property and your Mr. and Mrs. Mead's property as well. Right. Okay. That's fine. That's fine. Yeah, that's fine. So with that, I think what we'll do is we will adjourn now. And we'll be, I suppose we're going to be resuming for the site visit, but we'll be resuming for the evidence giving sessions on, I'll get my day right, Thursday, the 29th. It's a virtual format, and we will be starting at 9:30 in the morning, as per the programme that's been published. So with that, is there any other questions before we? No. Right, okay. So we it's now just before 12:30, and this inquiry is adjourned. Thank you very much.
Thank you.